Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk on a wide variety of topics that we've been covering, from finance and family law to Social Security, workers' compensation, and most recently, personal injury. In our last few segments, we've been covering personal injury, most recently automobile injury, some slip and fall cases, and as we approach this segment, we're going to discuss insurance, compulsory limits, what insurance about some of the pitfalls we'll discuss. And if we have time, a little bit of medical malpractice, another hot and very contentious issue. With our lawyers, Jackie Grasso and David Bazar from Audette, Bazar, Cordeiro Grasso law firm in East Providence, we always ask at the end of each session that you email questions to dbazar@abcglawfirm.com, and we have questions that we're following up last segment. So I will turn this over to David, who has the question.
Right, the question regarded a slip and fall, and it was someone who was on their way into work before work actually started, slipped and fell in the employee's parking lot and had a severe injury and wanted to know what rights, if any, they had.
What state are we in?
Well, this was actually not specific, so I'm going to say you can answer both Rhode Island and Mass if you want.
Okay, we'll try Rhode Island first. Rhode Island has what's called a going and coming rule, which basically means if you're on your way into work and you fall on or near the premises of your employer, you have a claim for workers' compensation. You may possibly also have what's called a third-party claim for the injury that happened in the parking lot, especially if the parking lot is controlled by the owner of the property. So you may have a third-party claim there for negligence. What did they slip and fall on? Was there ice? For whatever reason.
So it has the same components that we were talking about last time about negligence. You have to prove all of those issues. Correct.
Unfortunately, in Massachusetts, you do not have that going and coming rule. The only difference, there's a slight distinction. If you're a salesman, perhaps, and you're on the road, then you are deemed in the course of your employment. But if you're just coming to work in the morning and you haven't even gotten in the door, it wouldn't qualify as a workers' comp. I think you would just have a regular personal injury case or tort, whatever you want to call it, for negligence.
Yeah, and I think what you're saying, actually, Rhode Island does apply its going and coming rule similar to that. If you hadn't started work yet, clocked in, you're not on the clock, you're not working, you're not providing a benefit to your employer, then you might not qualify for comp. But if you're out on a break that was sanctioned, you know, and you slipped and fell, and it was something that was doing some benefit to your employer, then you might be able to recover. The suggestion there would be to see a lawyer who does workers' comp and personal injury.
Like everything, it's a gray area.
Right.
It's a gray area.
And you seem
need
to
somebody to really review the facts.
And you seem to point out that there's a very clear distinction between who is on the road as an on-the-road salesperson. That's a separate, or makes a muddier issue.
Well, it depends on what you're doing at the time you were injured. If you're an on-the-road salesperson, you're working for your employer and going from customer to customer or that type of thing. So if you're in the course of your employment and you're injured, it's a workers' comp case. If you're what they might call in a frolic or
frolic, yes.
Doing your own personal type of activity, it's not going to qualify for workers' comp.
Okay, fair enough. So, as you were starting to talk about negligence and insurance, I guess that's a good segue. I think that there's a wide catch-all for negligence. How can you help us define, how is negligence defined?
Okay. There's the negligence that we're taught in law school, and if Jackie and I can remember back that far, we were told there's a duty, and then you have to determine whether or not the defendant breached that duty, whether that breach proximately caused an injury. So there are 4 things to look at. In the real world, lawyers, when someone comes into their office, looks at it slightly different. They want to know, are there damages and how significant are the damages? Was there liability that caused your damages? And is there a deep pocket to recover from? And that's where the insurance would come into play.
Who's got the deep pocket?
Well, the defendant that hurt you, you would hope has the deep pocket. And usually the way their pocket is deepened is by having insurance coverage. And in Rhode Island, as we started talking at the beginning of the show, there is mandatory insurance coverage for automobiles.
And that presumes that everyone has such insurance, and as we were talking about it, that's not always the case. What happens then?
Well, that's why you want your uninsured coverage, because there's always that risk. Even if you don't get in an accident in Rhode Island, you might be in Idaho and they're not a compulsory state. You want to make sure you have underinsured and uninsured coverage in the event that there is an injury or a collision, whatever comes out of an auto accident.
What happens if they don't?
Then that's when if you yourself carry uninsured coverage, then you can make a claim against your own policy. As for the driver not having insurance, they can be cited for that. They can have their license suspended, and at the same time, they leave themselves open for personal liability for any damages that occurred as a result of their negligence.
Right. There's exactly two aspects to the question you were asking. The one is what happens to the driver who doesn't have the coverage, and that's what Jackie just explained. And the other side of the question is, what if you're involved in an accident with someone who doesn't have insurance and you're injured? And that was the coverage Jackie was explaining. Many automobile policies in Rhode Island are offered. Clients come in and say, I have full coverage. Well, what they usually mean by that is they have liability coverage for the situations where they hurt somebody. They have uninsured motorists, which in Rhode Island is uninsured and underinsured motorist coverage, which we'll explain in a little more detail in a second. MedPay coverage, which is coverage for their medical payments for bills that arise out of an accident that are required to cure or rehabilitate them from the accident. And coverage, of course, for the car itself, collision and comprehensive coverage to make sure that it can be repaired. The uninsured or underinsured motorist coverage is available in Rhode Island for situations where you get involved in an accident with someone and they have no insurance. Your policy will let you step into the shoes of the person who hurt you and recover your injuries your damages up to the amount of your injury in Rhode Island. It's not an expensive policy. Everybody should have that coverage.
Should but not must?
You do not have to have that. The only coverage that's required in Rhode Island is liability coverage to protect the person you hit.
I think the cost of is minimal, 100 or maybe even less.
Yeah.
The premium annually. It's not that
and
it's worth it.
In comparison to the cost of the rest of the policy, it's definitely worth it, and you really should have it, because it actually covers more than just that situation where the person who hit you didn't have insurance. In Rhode Island, the minimum coverage is $25,000. If you're hurt significantly in an accident, $25,000 is not going too far. What uninsured motorist does is then steps in as underinsured motorist coverage, which says if the person who hit you has $25,000 worth of coverage, but your claim is worth $100,000, then you can recover under your policy up to the limit of that claim. And that coverage could be another $25,000 if you have a minimal policy, or $100,000, or $300,000, or $500,000.
If such insurance exists and someone has an accident, if that insurance is in place, would they ever need a lawyer? The insurance is taking care of it, correct?
It's very complicated, and the insurance company is not in business to make sure you're compensated. They're in business to make money. And Jackie and I hear this all the time.
Quite often what will happen is we'll get somebody in our office inquiring as to the value of their case. They've handled everything else on their own, but they've gotten to the stage where maybe they're done treating. They may not even be done treating, but an insurance company is very deliberate in their actions, and they're forcing a settlement when it's too soon, and it's a minimal settlement. So when they'll come in to see us, we'll look at the facts, we'll look at the case, we'll even look at the medicals. We'll realize this person hasn't even been discharged. It may be worth far more than what the insurance company is willing to pay because of the damages or injuries and medical bills. The insurance company, their objective in every personal injury case is to save their company money. So minimize what they need to pay out.
So you're saying in all cases it's almost a buyer beware, not entirely buyer beware, but certainly it's not uncommon to hear an insurance company calling. It's a friendly voice, perhaps soothing,